Should I submit my pharmacy records in my Social Security disability claim? What a great question. Now, when you file a Social Security disability claim, they're going to be asking you a lot of questions about what kind of medical providers you've seen, emergency rooms, physicians, hospitalizations. They're also going to ask questions about what medication you've been taking and whether or not there are any side effects. And as a matter of course, the Social Security Administration is generally not interested in your pharmacy records, but they want to be looking at your medical records to see what your physician has to say about your compliance and your response. If there is an issue with compliance or your response to the medication or side effects, then those records may become relevant. Social Security expects that you're going to get appropriate medical treatment and be compliant with those treatment recommendations. And in some instances, Social Security may take the position that you don't meet the duration requirements, because if you were taking the medication, if you were compliant, you would have recovered and you would have been able to go back to work. And therefore, the medical records in combination with the pharmacy records can be important to document that you have attempted the use of medication, that you were compliant, and that you didn't necessarily get any benefit. Additionally, if it sounds like a judge is going to be unhappy with the compliance issues, I always want to submit those pharmacy records to show that in fact you got the medication, that you were compliant, and that you did what you needed to do. And despite that, you're still in pain and you haven't improved, and as a result, your compliance issues should go away. We don't want you to lose your Social Security disability claim because of compliance issues. If you have any questions about your rights to Social Security disability benefits or how to appeal a wrongful denial, call us today at 727-894-3188 for a complimentary consultation. Remember, if your initial application has been denied, you'll only have 60 days in which to file a request for reconsideration. If your request for reconsideration has been denied, you'll only have 60 days in which to file a request for a hearing. Now, if you blow those deadlines, you got to start all over again. You don't want to do that. So call us today at 727-894-3188 for a complimentary consultation, and let us help you learn about your rights and timely file any appeal. 727-894-3188.